Good afternoon. I'm Jim Duff, the Executive Director of the Supreme Court Historical Society, and it's my honor to welcome you today to our virtual platform for today's lecture. The Society was founded in 1974 by then Chief Justice Warren Burger to improve public understanding about the Supreme Court, the Constitution, and the judiciary. One of the elements the Society has utilized to do so is with our lectures on the court's history and its justices. Since the start of the pandemic, we have utilized Zoom to broadcast our lectures, and we are continuing to do so post-pandemic as we can reach a broader audience. If you've missed an earlier program, please visit the Society's YouTube page to watch them. We think you will enjoy them. Today's lecture is in observation of Juneteenth, and we are honored today to have with us the Honorable Curtis Collier, United States District Court Judge for the Eastern District of Tennessee, residing in Chattanooga, Tennessee. And he is going to deliver our lecture today. We're going to discuss the horrific history of the lynching of Ed Johnson in 1906 in Chattanooga, and the aftermath, which led to the only time the Supreme Court of the United States has sat as a trial court in United States versus Shipp. We will leave time for questions from the audience, so please drop your questions into the Q&A box on Zoom, and we will get to as many of those as we can. Judge Collier is a dear friend and is one of 9 children born to his parents in Marianna, Arkansas. Judge Collier attended Tennessee State University, where he majored in chemistry. He was a member of the United States Air Force Reserve's Officers Training Corps, a unit at Tennessee State, and he was commissioned as an Air Force officer upon graduation in 1971. Following his graduation from Tennessee State, Judge Collier attended Duke University School of Law and graduated with his Juris Doctorate degree in 1974. Honoring his commitment to serve in the Air Force, Judge Collier entered active duty after his graduation from Duke, and he served in the Air Force Judge Advocate General's Department as an assistant judge advocate with the rank of captain. Following his separation from active duty, Judge Collier joined the United States Department of Justice as an assistant U.S. attorney in 1979 in the New Orleans office, where he worked initially in the General Crimes Unit. He also worked in Chattanooga, Tennessee as a supervisory assistant U.S. attorney in charge of the Chattanooga branch office of the U.S. Attorney's Office for the Eastern District of Tennessee. Judge Collier is the first African-American to serve as a federal judge in the Eastern District of Tennessee, and the second African-American federal judge to serve in the state of Tennessee. He was appointed by President Bill Clinton in 1995. He served as chief judge from 2005 to 2012, and he took senior status in 2014. We first met when we served together on the board of the Federal Judicial Center. Judge Collier also serves on the board of directors of the Chattanooga Area Urban League, and he sits on the board of trustees at his church, Second Missionary Baptist Church. Welcome, Judge Collier. We're honored to have you with us today. And I will give a brief overview of the Ed Johnson case as we begin a discussion and ask a few prompting questions just to facilitate your descriptions of this matter and its importance in our history. The Ed Johnson case, unfortunately, was not an isolated outlying incident in our nation's history, but it was unique in many ways. First, it's a very well documented case. Second, it gave rise to the only case in which the Supreme Court sat as a jury in a case. It is so because of the heroic actions by several people in the face of mob violence. Those heroes include a local attorney in Chattanooga, Tennessee, Noah Pardon, and John Marshall Harlan, a justice of the Supreme Court of the United States. Because of the actions of these and others, we have an opportunity to learn from our nation's mistakes. And as Judge Collier has said in past presentations that I've participated with him on, we can learn of the timeless importance of the rule of law and the independence of the judiciary to learn the value of adhering to our Constitution, even when the public cries out for something short of those values. It is indeed an honor to have you with us today, Judge Collier. And let's start first with if your description about the crime, and we'll go through a series of questions in your discussion and conclude with, again, why this case is so important in American legal history.
Jim, it is an honor and a pleasure to be here with you at this lunchtime. This is a very, very important case. And it started out as an ordinary day for 21-year-old Nevada Taylor. On Tuesday, January 23, 1906, she gets off from work in downtown Chattanooga, and she takes the trolley car from downtown Chattanooga to the area of her home near St. Elmo at the foot of Lookout Mountain in Chattanooga. It's about 6:30 p.m. It's a very, very dark night. And she's walking from the trolley stop to her home. She's grabbed from behind by an attacker. She's blindfolded. A strap is wrapped around her neck. She is unconscious as a result of being choked. She's unable to identify her attacker. Her description is very, very vague. What she says is he was of average height. He had a very soft kind of voice. She could only describe his basic size and voice. Initially, she was uncertain whether the attacker was Black or white. The authorities and locals immediately made the assumption the attacker was Black. A search began almost immediately for the attacker, and news of the attack circulates widely. In 1906, Chattanooga had just experienced a series of crimes that were had some racial component to them. There had been assaults, there had been murders, and there had been a great deal of racial tension as a result of it. The media immediately got into the rape, and there were a lot of inflammatory statements made. One of the newspapers had this to say: "It has been an unwritten law in the South since the memory of man runneth not to the contrary, that the Black man who assaults a white woman shall die. This law maintains in every Southern state and is higher than any statutory law." Newspaper articles called the attack a brute. They called out for immediate arrest and punishment for the attacker. The attention was so great that the sheriff, and that was Sheriff Joseph Shipp of Hamilton County, Tennessee, offered a $50 reward for the capture of the suspect. This attracted regional attention. The governor of the state increased the reward to $375, and that'd be about $10,000 in today's money. About 2 days later, on Thursday, a fellow named Will Hickson tells Sheriff Shipp that he saw a man twirling a leather strap near the trolley station on the night of the rape, and he identifies this person as Ed Johnson. Ed Johnson is tracked down, and he's arrested. There's another Black fellow named James Broughton, who's also arrested because he fit the vague description that was given. There was such an outcry as a result of the arrest that a mob assembled and actually attacked the jail, where the mob thought that Johnson was being held. The county judge at the time, Judge Samuel McReynolds, had ordered that Johnson be taken from Chattanooga because of hostility to Nashville. So Johnson and Broughton were taken to Nashville, where they were held. The mob was about 1,500 people or so, and attacked the jail. It broke all the windows out. It damaged the doors. They were armed. They made threats. The city police was called to assist the deputies, the sheriff's deputies that were guarding the jail, and they were overrun. The governor was notified. The governor calls in the National Guard. The National Guard is also overwhelmed. The jailers tell the mob that Johnson is not there, that all their effort is in vain because Johnson's not there, that Johnson's been moved. The mob does not believe the jailers. The judge then arrives on the scene, and the judge tells them that Johnson is not there, and that if they will just be patient, that justice will run its course. He says, and I'm quoting here, "I hope that before week's end, the rapist will be convicted under sentence of death and executed according to law before the setting of Saturday's sun." The mob also disbelieves him. So the judge negotiates with the mob for a small group of men to go into the jail to verify that Johnson was not there. So 5 members of the mob go with the judge into the jail, and they go from cell to cell, room to room. They inspect the entire jail, and they do not find Johnson there. They report back to the mob that Johnson is not there. The mob dissolves. Taylor's taken to Nashville to identify her attacker. She views both Johnson and Brody, and she gives a very, very weak description of Johnson. She says that he is like the man as I remember him. So the following day, Johnson's charged with rape. He's indicted by the grand jury on a rape charge. And one of the really concerning points of this narrative is how the media attention coincided with the re-election prospects of the Sheriff Shipp, the Judge McReynolds, and also the district attorney. All 3 were facing re-election, and this was a high-profile, intense media attention case. So we have the rape, we have a very quick investigation, and we have the identification of Johnson.
And I understand that the trial was very unusual too, and the method in which the suspect was identified, and there's many questions that were raised about that. Can you describe that for us, please?
Well, as I said, the sheriff, the judge, and the district attorney all run for re-election. And this would not happen in today's times, thank goodness. But the judge meets with the district attorney and the sheriff to plan a strategy for trial. The sheriff is still concerned about Johnson's safety because of the mob action and the sentiment in the community. So he wants to keep Johnson in Nashville, the sheriff does, for his safety, but also to get more time to try to get a confession from Johnson. The evidence right now is very, very weak. The victim has not given a definitive identification of Johnson. It's very, very weak. Johnson not confessed. So the sheriff would like more time to try to get a confession from Johnson. The sheriff refuses. He reminds the sheriff and the district attorney of 2 things. First, it was an election year, and people demanded swift and certain justice. Second, he had promised them all the trial would take place quickly and he would not go back on his word. Now, this is another fascinating issue here. How much should we give a mob when they extort something from us? I'm not sure that a promise made to mob ought to be fulfilled, but that was over 100 years ago, and things are very different now. So the 3 agreed that the trial would take place as soon as possible, maybe within the week. The judge appoints 3 lawyers to defend Johnson. The first 2 were civil lawyers, and the very first one had no experience at all in criminal cases and very little experience even in civil cases. The third was a very experienced criminal defense attorney. They were appointed pro bono, which meant they were not going to get paid, and also they would not be paid to investigate the case or to obtain witnesses. At the time of the appointment, the judge tells the 3 lawyers he will not entertain a motion for a change of venue or a delay in trials. He tells them not to file such a motion, and that if they filed it, he will not grant it and would only make him angry. The sentiment from the public was such that the lawyers received threats. Their homes and businesses were vandalized. One of the lawyers lost his best client, and they also faced ostracism from the community. There was a great rush to trial. The judge ordered the trial to start on Tuesday, February 6, 1906. Remember when the rape occurred? The rape occurred just 2 weeks earlier. So this capital trial was going to start 2 weeks from the time of the crime. Although the judge had told the lawyers that he would not grant a change of venue or more time, the lawyers resisted that. And even though he'd warned them not to do so, one of the lawyers made this statement at the beginning of the trial: as appointees for a man arrested for the worst crime known to man, whose life is involved in the issue, in the face of law and in the interest of justice, we do not believe we have had sufficient time to develop facts to our satisfaction. We do not believe that this is the time or Chattanooga the place to try this case. The defendant ought to be tried at a late date and in some other county. We argue this not for the sake of delay, but that justice may be done. The judge would not change his mind. He responded that he thought the trial should take place as soon as possible and that it would be in Chattanooga. A Johnson had been in Nashville, and an armed convoy brought Johnson back to Chattanooga. Some of the question aspects of the trial were that the entire venire did not contain any blacks. So there were no blacks on the grand jury that returned the indictment. There were no blacks on the jury. Johnson presented a lot of evidence that suggested he could not be the person who committed the crime. Well, Hickson was one of the key witnesses, and the defense challenged his testimony because it was an extremely dark night, and he was standing where he said he was standing, and he saw someone standing where he said the person was standing. It would have been impossible for him to identify anyone. He was also challenged with interest in getting money. As I said, in today's money, he got $10,000 for identifying Johnson as the perpetrator. Taylor was the most important witness, but she never gave a definitive identification on the stand. The juror asked her she be brought back. She was brought back, and the juror asked her, "Is this the man who raped you?" And she said something to the fact that, "I think this is the man, but I cannot swear that he is the man." Whereupon one of the jurors leaped out of the jury box, reached out toward Johnson and said, "If I could get at him, I would tear his heart out right now." There was a mob intimidation out on the streets. There was also mob intimidation in the courtroom while the trial was going on. As one of the defense attorneys asked a series of questions of Johnson, people in the courtroom hissed and heckled and shouted. Johnson's parents were barred from attending the courtroom. As I said earlier, there were threats to defense attorneys who were representing Johnson, and the judge was not open to a change of venue or a delay in the trial, which obviously the facts suggested those would have been reasonable options for the judge to do to ensure that this trial was fair. After the third day of trial, the jury was not able to reach a decision. It was a deadlock, and I think the vote was 6-4, and they deliberated for 6 hours. So judge sent them home. The sheriff asked for a list of all the jurors, and the name of the jurors were also released to the press. So the next morning, well, it was actually that night because it was afternoon paper, all the name of the jurors were in the newspapers. And that raised the prospect that members of the mob or other people unfriendly to a fair trial intimidated the jury. So the jury assembles the next morning, and very early, they reach a unanimous decision of guilt. The judge then has to decide what the punishment is going to be, although there was only one punishment at that time. Tennessee had, I believe, a very unusual law at that time, and it was that if you were convicted, you had to announce at the time of the sentence whether you were going to appeal the sentence or not. The defense attorneys told Johnson that he had this right, but if he got up in open court and stated that, he would be lynched on the spot. So the advice they gave him was, Ed, there are two choices here. You can accept the verdict of the court and die in an orderly, lawful manner, or you can die horribly by the hands of the mob. Do you want to die at the hands of the mob? Do you want to die in an orderly fashion? Or do you want a lynch mob to take you from your cell, drag you to the streets, beat you, and hang you in front of everyone, leaving your body there for all to see? You can imagine what a difficult decision this is. Johnson accepts his lawyer's advice, and he states in open court, I am not guilty, but I see somebody will have to die for this crime. And it might as well be me as anyone. One of his lawyers later wrote in the newspaper, the life of the defendant, even if the wrong man, cannot be saved. An appeal would so inflame the public that the jail would be attacked and perhaps other prisoners executed by violence. The defendant, now that he has been convicted by a jury, must die by the judgment of the law, or else, if the case were appealed, he will die by the act of an uprising of the people. Judge McReynolds sentences Johnson to death by hanging for about a month away, for March 13, 1906. They're still concerned about mob violence, so Johnson moved to Knoxville for safety. So he's confined in jail in Knoxville for his safety.
Two African-American lawyers entered the case at some stage. If you could describe that for us, please, Judge, and also Johnson's defense and witnesses that would have testified with regard to his whereabouts at the time of the crime.
Johnson put on a very vigorous defense. It was not purely a prosecution evidence trial. Johnson testified, took the stand to testify. He testified that he was actually at his part-time job at the Last Chance Saloon, which was across town. And there was no way he could have gotten from the Last Chance Hotel to the scene of the rape. He called a number of people who were at the saloon at that time, and they all testified that he was there, they saw him, and he was working. The prosecution tried to undermine the testimony by suggesting that they did not have a true conception of the time, and they testified there was a clock on the wall, and they all noticed the time on the clock, and that he was there at about the time that the rape took place. Prosecution then put on some evidence that this clock did not work, that was stuck on a certain time, and the defense rebutted that with many witnesses who said the clock in fact did work, that sometime in the past the clock was not working, but the time the rape occurred, the clock was in fact working, and it kept accurate time. So the evidence against Johnson was very, very weak. It was Hickson's testimony, and Hickson's testimony was questionable because it was a very dark night, and the rape took place in a dark area, and he was motivated by money, and the victim was not able to ever give a definitive testimony. She said that he seemed like the person, but she never said this was the person who raped her. So the evidence was not overwhelming by any means. Justice convicted. Johnson is facing the death penalty in a little bit more than 30 days away. And his father enters the scene. His parents were not allowed to attend the trial. They were kept out of the trial. And they've given up hope with the trial lawyers. And their approach, two lawyers, there were two very prominent lawyers in Chattanooga at the time, Stiles, Lynch, and Hutchins, and Noah Pardon. Stiles Hutchins is a remarkable man. He was born in Lawrenceville, Georgia in 1852. He was purchased out of slavery by his father. His father was a barber and ran one of the largest barber shops in Atlanta, Georgia. And he trained Hutchins to be a barber. After the Civil War, Hutchins went to Clark Atlanta University, where he obtained a degree. He then taught school and was headmaster of a school for newly freed Blacks in Athens, Georgia. He then attended the University of South Carolina Law School, where he obtained his law degree and graduated in 1876. He practiced law in South Carolina. He was appointed to a state judgeship there. Because of rising racial hostility, he left South Carolina and moved to Georgia. He was the very first Black person admitted to the Georgia bar. He then moved to Chattanooga in early 1880s because Chattanooga had a very friendly and welcoming environment for African Americans, especially African Americans who aspired to do well. His practice did very, very well. He represented people in civil rights matters. In fact, about 5 or 6 years earlier, he had represented the wife of another man who had been lynched on the same bridge as Johnson was. Hutchins ran for a state representative position in Tennessee and won, and he served from 1887 to 1888. He and one other Black were the last Black elected state officials in the state until 1964. He also owned and ran a newspaper. He was an admirer and follower of W.E.B. Du Bois. He was joined in his practice by a younger lawyer, about 15 years younger than he was, named Noah Pardon. Pardon was also from Georgia. He was born in 1865. His childhood was spent on a farm in rural Floyd County, where he performed farm labor. He came to Chattanooga to attend the Howard High School. Howard was one of the few high schools, public high schools for Blacks at that time. So if you were Black and you lived anywhere within a 50, 100-mile radius of Chattanooga, you wanted to go to high school, you had to come to Chattanooga, and Howard High School was the place. After Howard High School, Pardon went to Howard University in Washington, but did not graduate. In 1889, he entered Central Tennessee College of Law in Nashville, where he graduated as valedictorian in just 2 years. After law school, admission to the bar, he came to Chattanooga and entered practice with Stiles Hutchins, and together they represented 2/3 of the Black population. Unlike Hutchins, Pardon was a follower of Booker T. Washington. The Ed Johnson case attracted an awful lot of publicity. Almost all of it was negative. These two men understood the hazards of taking on this case with all of the racial animus that surrounded it. So these two lawyers have a practice, a thriving practice, and Johnson's father approaches Pardon, and he's talking to Pardon. Hutchins is in the other room. Hutchins can hear what's going on, but he does not participate in the conversation. And the father begs Pardon to take on the case. He says that the lawyers who were appointed have done all they can, but obviously more needs to be done. He begs him to take on the case. And Pardon says no. Pardon knew that if they took on this case, that their practice would be severely hampered, and they might even face physical repercussions from it. So the father leaves what they know from Pardon. Hutchins then comes in, and Hutchins tells Pardon he heard the conversation, and he thinks they should take on the case. And he tells him that they have been very fortunate in their lives. They have acquired an awful lot, and to whom much is given, much is required. So they agree to take on the case. Hutchins then goes to the courthouse. He examines records. He may have interviewed witnesses there, and he tries to get a grip on what is involved. They go back to the judge. They ask the judge for a different decision on a new trial or appeal. They're turned down by the judge. They petition the governor. They're turned down by the governor. So they've exhausted all efforts on the state level. They've done everything that's conceivable at that time to get relief on the state level.
And at that point, what was the strategy? Where did they turn, and to whom did they go from there?
Well, in football, if you have a few seconds on the clock and you're at the 40-yard line and you're down by less than a touchdown, what you do is throw the Hail Mary. As you go back and throw the ball up in the air as far as you can, and you just hope that somebody will catch the ball. That's what they did. The law at that time was that the federal courts had no authority to intervene in state prosecutions, that the state criminal systems and the federal system were completely different animals, and one had nothing to do with the other. And the law was very, very clear. There wasn't any confusion at all. The law was very, very clear that the federal courts had no jurisdiction to intervene in state court prosecution. That's what they do, though. They throw a Hail Mary and they file a petition for habeas corpus before the district court judge in Knoxville, Tennessee, knowing that the chances of prevailing were very, very low. And the judge does give them a hearing. He gives them a hearing over the weekend on Saturday and Sunday. The hearing takes two days. Witnesses are presented. A large number of people from Chattanooga come up, blacks from Chattanooga come up to watch. The judge was Charles Dickens Clark. Judge Clark was a Chattanooga resident, although he was sitting in Knoxville. Judge Clark, at the end of the hearing, agreed there may have been serious flaws in the trial, but concluded that the Sixth Amendment guarantee of a fair and impartial trial did not apply in state court. That was the prevailing law. So he denied the petition, but he also entered a stay of execution. So he extended the time for the execution to allow Pardon and Hutchins time to appeal to the Supreme Court if they disagree with his decision, which of course he did. Now, while this was going on, the building where Hutchins and Pardon's law office was set on fire. No one was injured. Their families were also threatened, and they also lost substantial legal business and physical threats. So then another hero enters the picture. Judge John Marshall Harlan. Judge Harlan was called the Great Dissenter. He was the dissenter in Plessy versus Ferguson, but he was also the dissenter in many of the most important cases that Supreme Court heard between the end of the Civil War and about 1920 or so. And in many of his dissents, his thoughts later became the prevailing opinion. So he's called the Great Dissenter for a reason. Judge Holland was a justice who was assigned to the Sixth Circuit. And the Sixth Circuit now is Michigan, Ohio, Kentucky, and Tennessee. So the Sixth Circuit back then included Tennessee. So he was a justice who heard appeals initially from Tennessee. So Hutchins and Pardon did not give up. They lost on the first round, but they prepared a brief to the Supreme Court raising important and significant issues. They filed the brief, and then Pardon, the younger of the two, took the train from Chattanooga to Washington, and he asked for an audience before Justice Harlan. He was not admitted to practice before the Supreme Court bar at that time, so he prevailed upon a law professor at Howard University Law School. who was admitted to the bar, to introduce him, which he did. So he was admitted to the bar, and Justice Harlan gave him an audience. He spent a good 15 minutes or so hearing Pardon out, asking questions about the facts, asking questions about the law. He did not indicate what his decision was going to be. This is one of the first times, well, not the first, but one of the first times that a Black man had argued a case in the Supreme Court. And it was one of the first times a Black man had been the lead lawyer in a Supreme Court case, not the first, but one of the first. So we're seeing a lot of new ground being plowed here. To everybody's surprise, Justice Holland granted the petition, at least for oral arguments and for briefing. But that also meant that the execution would be put off. So the case was accepted for argument. The stay of execution was granted. And there were very few federal prisons back then. So what the court would do, and the court did in this case, was to inform the sheriff that Johnson was now a federal prisoner, that he was no longer a state prisoner, but he was a federal prisoner so long as the Supreme Court was looking at the case. And he was being placed in the sheriff's custody for safekeeping while the case was pending. So we have two of our heroes, the two lawyers who stepped in, who achieved something that's never been achieved before. The Supreme Court has actually intervened in a state prosecution. We have Justice Harlan, who's another of our heroes, who's now made his appearance, and he's done something that's never been done before.
And what was the reaction of the townspeople in Chattanooga learning that the Supreme Court had granted a stay?
The Supreme Court sent a telegram to the sheriff, to the federal judge, Judge Clark, state judge, Judge McReynolds, and everyone else involved, including Hutchins. Pardon was on the train, so he could not have received the telegram. That the Supreme Court had taken the case, that a stay had been entered, a stay of execution had been entered, and that Jones was now in the sheriff's custody. Some people in Chattanooga were outraged. They were offended. No one expected that the Supreme Court would actually intervene in the case and would put off the execution. And is that newspaper statement I read earlier, it was unwritten law that if a Black man raped a white woman, that the person had to be killed. The telegram announcing the acceptance of the case was printed in Chattanooga newspapers for the entire city to read. News of the Supreme Court's action shocked many people, and word spread quickly. The possibility of mob action only heightened. Just had been brought back to Chattanooga by this time, so he was in fact in the jail. Unlike in the case of serious threats that the sheriff knew previously, the sheriff decided to take a completely different approach this time. Recall earlier he had sent Johnson to Nashville, sent Johnson to Knoxville. This time it chose to keep Johnson in Chattanooga in the jail. And he does a few things that are remarkable. The first thing he does is to give all of the jailers the night off, except for one elderly jailer. So there's only one elderly person in the jail to protect the jail itself and the prison. The second thing he does is to move all the prisoners off the floor where Johnson's housed, with the exception of one white woman who's charged with bootlegging. So on this floor, there are only two people, Johnson and one white woman. And of course, the mob did come to the jail. The mob was armed with guns. They brought crowbars, sledgehammers, and other tools to breach the doors. For some 2 hours, they beat on the doors, they battered the doors, they broke the windows. They finally broke through the outer doors. There was an inner door that they also broke through. And then they entered the cell block where Johnson is. They locate Johnson in his cell. They forced that cell to open. They grab Johnson, and they take Johnson out of the cell, out of the jail, onto the streets, and they take him to the Walnut Street Bridge. And there he is lynched. They find a rope on one of the trolley cars. They pull the rope off. They put the rope around his neck, and they demand that he confess. Johnson does not confess. He reasserts his innocence. He says, "I'm ready to die, but I never done it." Before the noose is tightened, Johnson utters his last words, his final words. "God bless you all. I am innocent." Johnson dies a brutal death. He does not die from the rope, but rather from a plethora of gunshots into his body. The mob was not, did not know how to tie a hangman's noose, and really did not want to hang someone, so they put the rope around his neck and just pulled the rope. So he's actually strangled to death at the end of the rope, and his body is struggling. And the mob gets impatient that he's not dying quick enough. So they start shooting him. They pull out the guns, they shoot him. And one of the bullets fired strikes the rope and breaks the rope. So he falls on the bridge. His body is full of bullet holes, but he's still alive. And then one leader of the mob steps up, puts a revolver to his head, and fires 5 rounds into his brain, which killed him. One of the leaders of the mob steps up and pins a large note to Johnson's still warm body. This note says, "To Justice Harlan, come and get your N-word now." The bulk of Black population live north of the river. The Black population was assembled in Chattanooga during and after the Civil War because Chattanooga was a Union hub. It was a depot hub, and a lot of us slaves escaped slavery in Tennessee, South Carolina, Georgia, Alabama, and Mississippi to come to Chattanooga to escape slavery. And that area of Chattanooga, just north of the river, was where they lived. So to get to Chattanooga, where many of them worked, they had to cross this bridge. So they would not cross the bridge, and many of them protested by refusing to work. This is the Walnut Street Bridge. Now it is a major tourist attraction in Chattanooga now.
It's just a brutal story and brutal part of our history, unfortunately. And what was the Supreme Court's reaction upon learning that Johnson had been lynched?
The Supreme Court was horrified. They were outraged. For the first time ever, they intervened in a state prosecution, and instead of the orders being obeyed, it appeared that their orders were being ignored, and actually the message was being sent to them. The person who put the note on Johnson's dead body did in a crude manner, but the Supreme Court took this as an affront to their authority. Justice Holland said, whether guilty or innocent, one of the Supreme Court, whether guilty or innocent, he had the right to a fair trial. And the mandate of the Supreme Court has, for the first time in the history of this country, been openly defied by a community. And they knew they could not let this stand. There had to be a forceful and vigorous reaction. They discussed with the Attorney General what action might be available. President Roosevelt was also consulted. And Roosevelt authorized an investigation. 2 Secret Service agents were sent to Chattanooga to gather evidence about the night of the lynching. So they traveled to Chattanooga with the assistance of Pardon and Hutchins. They located numerous witnesses who could identify people in the mall and also describe what happened. The investigation moved quickly. About 2 months after the lynching, the Attorney General asked the Supreme Court permission to file charges against 25 citizens of Chattanooga, including the sheriff. The Supreme Court granted the permission. So Shipp and 25 others were indicted for contempt of the Supreme Court's orders. Before the trial, the charges were dropped against 19 of the defendants, but the other 6 went to trial. And the Supreme Court, after hearing the case, hearing the evidence, found these 6 defendants guilty of contempt of court and sentenced them to prison. Edward Terry Sanford, who was a Knoxville lawyer, who was a special assistant attorney general for the Justice Department, was assigned to prosecute the case. He was a Knoxville native, and he later became a district court judge in Knoxville and was elevated to the United States Supreme Court from the district court bench. The only time in our history that a district court judge has been elevated directly to the United States Supreme Court. So as a result of Johnson's lynching, the Supreme Court, for the first time, acted as a trial court, conducted a trial, found individuals guilty, and imposed sentence. That has never happened before. Now, one of the lasting effects of this is that it has demonstrated to the country that federal courts have the authority to enforce their orders without resorting to state authority or other authority. Later on, this becomes important because during the civil rights movement, we had some governors and some other public officials indicating they would not integrate schools, they would not do this, they would not do that. But when push came to shove, they all obeyed. Because I think they understood that the federal courts, if necessary, could enforce their orders by confining people who disobeyed their orders. So that was a very important precedent.
And this led to other legal developments. It's you're describing the initial habeas petition. We take it.
In every term of the Supreme Court, there are death penalty cases. Supreme Court takes up. They may hear them, they may not hear them, but at least they consider whether they should be heard or not. Most of these cases come from the states where someone has been convicted in a state court and they've been sentenced to death. Those cases all get to Supreme Court because of habeas. That started with the Ed Johnson case. Now, the Supreme Court did not have a chance to actually state the principle because Johnson died before the case could be decided. But the principle that they allowed as a possibility was in accepting Johnson's case. About 10 years later, in the Leo Frank case, Supreme Court faced the question again squarely. Leo Frank was a young Jewish man in Atlanta who was charged with raping a white woman, and there was also mob violence there. He was tried. He was ordered to be sentenced to death, and his lawyers argued that the mob atmosphere prevented a fair trial. The Supreme Court for the first time acknowledged that if there was mob violence that was pervasive, that might constitute a violation of the Constitution, that may constitute a violation of the due process law. But they said that Leo Frank's case did not present sufficient facts to demonstrate it. And of course, as we know, after the Supreme Court decided, the mob broke into the prison, the state prison, not a county jail, the state prison, located Frank, took Frank out, took him back to Marietta, Georgia, and they lynched him. There are many, many photographs of Frank's body hanging from a rope available for anyone that's interested. And then about 10 years after that, the Elaine race massacre case, Supreme Court took the case up again. A number of black sharecroppers were meeting, looking at the possibility of forming a union, and some people drove by in an automobile. Some shots were fired. People in the church fired back. When the blacks were meeting, fired back, and someone in the automobile was killed. There was a huge outcry after that. Many blacks were killed. About 25 blacks were charged with murder. And the state tried them in groups of 5 to 8. The trials took 30 minutes. They were all found guilty and all sentenced to death. Again, you had mob violence outside, pervasive mob violence, intimidation. And the Supreme Court, for the first time, said this constitutes a violation of due process clause, and this will not stand. A trial, to be constitutional, must be fair not only in procedure, in form, but also in substance. And that comes directly from the Johnson case. So that laid the groundwork for all the habeas cases that we see today, not only in death penalty cases, but also in other alleged violations of constitutional rights that state courts might be alleged to have committed. So there are a number of really important consequences of this case. Modern habeas is what we have. We won't touch on this too much, but Terry Sanford, who was a prosecutor in the Ed Johnson case, who later went on to become a judge, later Supreme Court justice, was the author of Get Low versus New York, the incorporation decision. I always wondered if he had in the back of his mind when he wrote that decision what happened to Ed Johnson, and how the protections were not really sufficient and more needed to be done. And of course, the incorporation doctrine now allows for all of the federal rights that we see litigated in our federal courts and also our state courts now. So is this possible? I can't prove that. I'm not sure anyone else can prove that, but it is possible that Johnson also laid the foundation for modern civil rights litigation.
Well, it's as we discussed at the very outset, the repercussions and impact that this case has had on future other legal developments in the aftermath of it has been profound, and we're indebted to the heroic actions of attorneys Hutchins and Pardon, and that they took the Hail Mary pass and to the Supreme Court, and so it documented this horrific story and enabled some progress to be made in the aftermath. Very grateful for your discussion of this today, Judge Collier, and we want to take some questions from our audience, which I have in front of me. I'll repeat a couple to you and get your responses to those and further discussion. How do you see Justice Harlan's role in pushing towards the contempt proceedings to have played out? Is he responsible for getting the court to take such an extraordinary measure?
He is the single person who's the force behind the punishment. There's a great book now called The Great Dissenter. It's a relatively new biography of Justice Harlan. He actually talks about Justice Harlan's steps, and Justice Harlan approached the Chief Justice Melville Fuller at the time, and they actually met at Justice Fuller's home on a Sunday, and they discussed this and what to do. So he was instrumental in Supreme Court deciding to take action here. I think he probably had a much greater interest in the case than others. Now, he was the one who accepted the case, and he was the one who persuaded the other justices that this is a case that they should intervene in. So I think he had more of an interest in the case than other justices, but it's to their credit that all the justices felt that they had to step up and do something. This was an affront to the entire court, and it had the potential of undermining the court's authority forever, and also in other arenas.
Excellent point. The book you're referring to, The Great Dissenter, the biography of John Marshall Harlan, is by Peter Canellis. And you and I had appeared on a panel at the Sixth Circuit Conference with Peter, and we had him as a guest on one of our programs earlier this year. We held off on going into great detail on this case, which an entire chapter is devoted to in his book, because I knew we were scheduled to have this discussion with you today. We do recommend that reading as well. I've noticed one of the people in our audience has noticed a lack of scholarship on the Shipp case in the underlying Tennessee versus Johnson case. Where did you gather your information from this talk, which is so informative and so detailed, and for which we are very, very grateful?
Well, the question is exactly right. There is very little scholarship and also not nearly enough knowledge about this very important case in our history. I got into it very accidentally. Here in Chattanooga, before I took the bench, the Black Lawyers decided to form a Black Bar Association here. And we weren't sure who to name the association after. We wanted to name it after a Black lawyer, and we were looking to see who the first Black lawyer was. There was a lot of confusion about who the first Black lawyer was. We had this name and that name and that name. And I decided to do some research on my own. So I went to the public library. I researched some old newspaper articles. There were histories of Chattanooga. It's a Black History Museum here. I went there and I found a lovely little book that talked about prominent Black Chattanoogans, and it was about 1903, 1904, something like that. And S.L. Hutchins was mentioned. And the book said he was the first Black person. So I then started doing a lot of work on him, and I verified he was the first Black lawyer to practice in Chattanooga. I've read that he had gone to the University of South Carolina. I did not believe that. I thought that that source was mistaken. And I researched that and found out that was actually true. He had in fact gone there. He graduated in that class. And as I was doing research, I discovered the Shipp opinion, the Supreme Court opinion, which also surprised me as I read it. And I actually did a monograph, a short monograph on Hutchins, and the Shipp opinion played a very, very big role in it. Then maybe 6, 7 years after that, the authors of another book, Contempt of Court, approached me and asked questions about my knowledge, and then they wrote a book dealing more with the lynching. Since then, there have been a few other books published, but again, not nearly enough to give this case the attention and the credit that it deserves in our history. And aside from the legal aspects of it, it also says an awful lot about the human condition. It's a story of hatred, of bigotry, but also of love and triumph and sacrifice. It has an awful lot about the human condition that we could all learn from.
Well, you're a hero too, Judge Collier, to many of us and to the country. And I think your work on this matter and elevating our public attention to it is really crucial. And we're very grateful for that. I also want to commend you on your work on civic education and your monthly, I subscribe to your monthly email, your initiatives in Chattanooga and nationwide. And you do remarkable work in that regard. And you're certainly doing your part and more for educating our public. We're dedicated to doing that too here at the Historical Society, and I look forward to working with you and in many other capacities in this regard. We're especially grateful today for you taking time to elaborate on the details of this case and its importance in American history and Supreme Court history. It was an inspiring talk on a very difficult topic, and much needed and much appreciated. Our
Thank you.
next, thank you. Our next event is on Monday, July 20th at 1 p.m. Professor Helen Knowles Gardner and Professor Dennis Hutchinson will be discussing her recent essay on the influence of Dennis Hutchinson's book on Justice Byron White on her own career. The essay appeared in the most recent issue of the Journal of Supreme Court History. And on Constitution Day 2023, we will be hosting a Zoom lecture with Judge Guido Calabrese and Norman Silber on September 14th at noon. Registration will be opening shortly for both of those events. And a reminder that a survey will go out this afternoon to everyone who registered in advance. Please do respond to it. We want to make these programs as informative and accessible to as many people as possible. Thank you for joining us today. Judge Collier, again, many thanks for your inspiring work. And with that, we are adjourned.